Welcome to this special deep dive. We're focusing today on a really crucial area of EU law, the free movement of persons and citizenship.
That's right.
This deep dive is brought to you by Sinorbit Academy, Sri Lanka. And just a note, these learning materials are made available to students by the University of London for educational purposes only.
So good luck to all of you preparing for your exams.
Absolutely. Today, we're really digging into the core principles, how individuals can move, live freely within the EU, and what EU citizenship actually means.
And we'll be drawing heavily on materials from the EU 2024-25 module, specifically those excellent Steiner and Woods chapters on citizenship, economic rights, and discrimination.
And of course, that key piece of legislation, Directive 2004-38-EC. Can't forget that one.
Definitely not. Our mission today really is to pull out the most important bits from these sources, give you a solid grasp on how these free movement rights actually work in practice.
We'll be looking at the key players, like workers, and how the rights have sort of evolved through some major court decisions.
Exactly. We want to keep it clear, focused, and hopefully avoid that feeling of information overload.
And we'll try to weave in some advice on how you can best tackle studying this area, too.
Sounds like a plan.
Okay, let's kick things off. Where do these rights actually apply? It's not strictly just the EU member countries, is it?
No, that's a great point to start with. The rights we're talking about stemming from Articles 45, 49, 56, TFEU, the Treaty on the Functioning of the European Union, they actually go a bit wider.
Wider?
Yes, they extend to the European Economic Area, the EEA. So that includes Iceland, Liechtenstein, and Norway as well.
Ah, right. So the scope is broader than just the EU member states. Good to remember.
Definitely.
Now, let's dive into the free movement of workers. This feels like, well, a central pillar of the whole thing. Article 45 TFEU, that's the starting point, isn't it?
Absolutely. Article 45 lays down that fundamental rule, no discrimination based on nationality.
Yeah.
That covers employment, pay, other working conditions.
And the Court of Justice, the EU's top court, they've taken quite a broad view of this.
Very broad, consistently. It's not just about people who have a job right now. It includes job seekers, even family members of workers.
And it's not just about obvious direct discrimination, is it? I remember reading about rules that seem okay on the surface, but still cause problems.
Exactly. The court has been clear. Even rules that apply equally to everyone, non-discriminatory rules, can still breach Article 45 if they basically make it harder for someone to get a job in another member state.
Hindering access, is that the term?
That's the one. The Bozeman case is the classic example here. You know, the UEFA transfer rules for football players.
All right, I remember that.
They applied to everyone, but the court said they hindered a player's ability to move to a club in another EU country. The logic was these rules could block access to employment unless there was a really good objective reason, and the rules were proportionate, didn't go too far.
So the big takeaway from Bozeman is this hindrance of access idea. Even non-discriminatory rules can be a problem.
Precisely. It's not just about banning obvious discrimination. It's about dismantling rules that unfairly obstruct working elsewhere. Remember Bozeman and hindrance of access.
So even if a rule doesn't explicitly target foreigners, if the practical effect is making it tougher for them to get work, it could be challenged under EU law.
That's it. And this hindrance principle, remember that term, was reinforced in the Craneman case.
Craneman, what was that about?
A German trainee lawyer doing part of his training in the UK wasn't fully reimbursed for travel costs. The court said, well, this could hinder his access to the legal profession in another member state, so Article 45 applied.
So similar reasoning to Bozeman, discouraging people from using their free movement rights.
Exactly. Discouraging them from leaving their home country it's seen as an obstacle.
But surely there have to be limits. Not every single little inconvenience can be an illegal hindrance, right?
Correct. There are limits. The Burbod case gives us an example. There was a requirement to pass an exam to work in the public service. The court said that wasn't in itself an obstacle to free movement. It acknowledged some non-discriminatory hurdles might just be too minor or too indirectly linked to actually getting a job elsewhere to trigger Article 45.
So it's a balancing act. Removing real barriers, but not every single hoop someone might have to jump through.
Pretty much.
Okay, so we've got the broad scope, non-discrimination, and this crucial hindrance idea. Now, who exactly qualifies as a worker under EU law? It's probably not as simple as just having an employment contract.
You're right, it's not. The court has defined worker very broadly. The Hoekstra case, quite early on, established that worker isn't just someone currently employed.
Oh.
It can include people likely to remain in a member state after having worked there. So it has this kind of forward-looking element too. Basically, if you've worked somewhere, you might keep that worker status for certain rights even after the job ends.
So Hoekstra tells us the definition isn't just about the present moment.
Exactly. Remember Hoekstra?
What about people doing part-time work? Or maybe earning very little, less than the minimum wage? Do they still count?
Yes, absolutely. The Levin case dealt with that specifically. The court said, yes, the definition covers part-time work, even if earnings are below the official minimum subsistence level.
So the amount earned isn't the deciding factor?
Not solely. The key thing, according to Levin, is whether the work is genuine and effective economic activity. It can't be purely marginal and ancillary, but part-time work definitely can qualify you. So remember, Levin, part-time work counts if it's genuine.
Genuine and effective economic activity. That phrase sounds important. What does it actually mean in practice?
Well, the Kempf case helped clarify. The work needs to be performed for some kind of remuneration, some payment, and it has to be, well, real work, not just something nominal or secondary.
And remuneration doesn't just mean a standard salary.
No. The Laurie Blum case showed that. Trainee teachers received pay for giving lessons they were considered workers. So there needs to be that link. Work performed in return for some kind of reward or compensation.
Okay, so remember Kempf and Laurie Blum. Genuine work for pay.
That's the core idea.
What about slightly unusual situations? Like, I think the materials mentioned someone doing work for a religious community.
Ah, yes, the Stamen case. The court considered that work done within a religious community where the person got accommodation and basic needs met in return for their services could count as economic activity.
Interesting. So pay can be indirect.
It seems so in that context. But you have to contrast Stamen with the Betray case.
Betray.
There, the work was part of a drug rehabilitation program. The court drew a line suggesting the primary purpose wasn't really genuine economic activity aimed at earning a living, but rather rehabilitation.
So the underlying purpose of the activity matters a lot. It's not just about the tasks performed.
Precisely. Stamen versus Betray shows that distinction. Later cases like Bernini also touched on this, suggesting even occupational training could qualify someone as a worker if they'd worked long enough to get familiar with the job, showing that real economic connection.
Okay, so Bernini adds that training might count sometimes.
Yes.
Now, what about people moving to look for their very first job in another member state? Are they treated exactly the same as someone who's already worked there?
Oh, the Collins case highlighted a difference here. The court drew a distinction between those who have already participated in the host member state's labor market and first-time job seekers.
A distinction how?
While job seekers are covered by Article 45, as we'll discuss next, the Collins ruling suggested that those who haven't worked in the host state before might not immediately qualify for the same social and tax advantages as national workers.
So Collins differentiates between first-timers and those with a work history in that country.
Essentially, yes.
Okay, let's talk specifically about job seekers, though. Article 45 mentions accepting offers of employment. How does that connect to just looking for work?
Good question. The court in the Antonison case interpreted the phrase to accept offers of employment actually made quite broadly. It decided this must include the right to move and stay to look for work.
Because otherwise the right to accept an offer would be meaningless if you couldn't go there to find one.
Exactly. A narrow reading would undermine the whole point. So Antonison established that Article 45 implicitly gives job seekers a right to move and reside in another member state for a reasonable period to seek employment. Remember Antonison. Job seekers have rights under Article 45.
And what did the court consider a reasonable period in Antonison?
Well, in that case, 6 months was seen as reasonable. But importantly, the court also said that even after that time, a member state couldn't just automatically kick someone out if they could prove they were genuinely still looking for work and had a real chance of finding it.
Ah, so it's not a strict cutoff.
Not automatically. This idea, reasonable time, right to remain if genuinely seeking work, is now reflected in Article 14b of Directive 2004-38.
So it depends on demonstrating genuine effort and realistic prospects, even after the initial period.
That seems to be the principle. Now, building on this, let's talk about the vital principle of equal treatment for workers and their families. This is really where free movement hits the ground, isn't it?
Absolutely. Once a worker moves, what rights do they have compared to local workers when it comes to actually getting a job?
The fundamental principle is equal access. Migrant workers should have the same chance at employment as nationals of the host state. No discrimination in recruitment.
Are there any exceptions?
A few, but they're limited. There's the public service exception in Article 45(4) TFEU. We'll come back to that. And Regulation 49201 allows for language knowledge requirements, but only if they're needed for the job.
And those language requirements have to be proportionate, right? That word keeps coming up.
Exactly. Proportionality is key. The Groner case is a good illustration. The court said, yes, you can require language proficiency, but the level demanded must be genuinely necessary for the job and not set unreasonably high.
So it has to match the actual needs of the position.
Yeah.
Remember Groner. Language requirements must be proportionate.
That's it.
What about other kinds of requirements? I think there was a case about needing a specific certificate.
You're likely thinking of the Anganese case. An Italian bank required a specific bilingualism certificate issued only by authorities in one particular province, Bolzano.
Even if the applicant was bilingual.
Yes. Even though Mr. Anganese was bilingual, he didn't have that specific certificate, so he was excluded. The court said this was disproportionate and contrary to Article 45. It was virtually impossible for someone outside that region to get the required proof.
So making requirements impossible for outsiders to meet is a no-go.
Pretty much. The Kozlowski case also touches on access to training needed for employment, suggesting that countries can't just automatically shut out applicants for teacher training without assessing their actual qualifications fairly. So Anganese is key for disproportionate requirements.
So host countries can't create overly restrictive or impossible hurdles for migrant workers trying to get jobs.
Correct. And alongside getting the job, the right to actually live there for work is fundamental.
The right to reside. Does that depend on getting a permit?
No, the right for a worker to enter and live in another member state for work comes directly from the treaty itself. Cases like Rutili and Otiza Olazabal confirmed this early on.
So the permit is just paperwork.
Essentially, yes, it's documentary evidence of a right you already have, not the source of the right. Directive 2004-38 now sets out the specific rules for these residence documents. Remember Rutili and Otiza Olazabal. The right to reside flows from the treaty.
Okay. And once someone is working in another EU country, they should be treated equally in other aspects too, not just recruitment.
Absolutely. Article 7 of Regulation 49201 is key here. It demands equal treatment regarding working conditions, pay, dismissal, and even getting back into employment if they become unemployed.
And crucially,
Article 7.2 extends this equal treatment to social and tax advantages on the same basis as national workers.
social advantages. That sounds like it could cover a lot. What sort of things fall under that?
The even case gave a broad definition. It includes advantages, whether linked to the employment contract or not, which are generally granted to national workers primarily because of their status as workers or just because they live there.
Can you give some examples?
Sure. The court has included things like discounted rail fares for large families, Christini, the right to use your own language in court proceedings in certain areas, much, even interest-free childbirth loans, Reina.
Wow, quite diverse.
It is. Cases like Dono and Gusa, which we'll touch on more later, also deal with access to benefits for people who aren't necessarily working, which connects to this broader idea. But even establish the wide scope of social advantages.
So it goes well beyond things directly tied to the job contract itself.
That's right. Even rules requiring a certain period of residence to get a benefit can be problematic if they indirectly discriminate against migrant workers, as seen in Commission v. Luxembourg.
Are there exceptions?
Yes, sometimes. For instance, in Baldinger, a benefit specifically for war victims linked to nationality for historical reasons was considered outside the scope of a general social advantage.
What about education and training for workers? Same access as nationals?
Yes. Kozlowski confirmed access to vocational training falls within the treaty's scope. And importantly, someone doesn't automatically stop being a worker just because they stop working to study full-time. That was the Lair case.
But there needs to be a connection.
Usually, yes. A link between the previous job and the studies is generally required. Although, if someone becomes involuntarily unemployed and needs retraining, that link might be viewed more loosely.
What if the work was just part of the studies?
That's the Brown case. A work placement that was just an integral part of a university course wasn't enough to make the student a worker for the purpose of getting a student maintenance grant. The employment was seen as ancillary to the studies.
Okay, so remember Lair and Brown, the relationship between the work and the study is key. And tax advantages. Can migrant workers be treated differently for tax?
Generally, no. The court has increasingly clamped down on direct tax discrimination that hinders free movement. Cases like Schumacher, Velox, and Ritter-Coulet have established that if an EU national earns most or all of their income in a host state where they don't officially reside,
Yes?
then that host state generally must take their personal and family circumstances into account for income tax purposes, just like they would for residents.
So Schumacher and related cases mean tax treatment should generally be equal too.
Broadly speaking, yes. The principle of equal treatment for workers is very wide-ranging.
Now, what about their families? Do they get rights too?
Yes, the rights of workers under the treaty generate what are often called derived rights for their family members. It's crucial for making free movement practical.
Starting with the right to live in the country with the worker, I assume. Who exactly counts as a family member here?
Directive 2004-38, Article 2.2 gives us the core definition. It's the spouse, a registered partner, if the host state treats registered partnerships like marriage, direct descendants under 21 or who are dependent.
Children or grandchildren?
Usually children, yes, and that includes children of the spouse or partner, too. Also, dependent direct relatives in the ascending line, parents, grandparents of the worker, or their spouse partner.
What about changes in the family situation, like divorce?
The Diata case clarified that even after separation or divorce, a non-EU family member might retain residence rights under certain conditions, like the duration of the marriage before proceedings began.
And same-sex partners?
The Coleman case was very important here. It held that, for free movement rights, the term spouse does include a same-sex spouse of an EU citizen who has exercised their right to move to another member state.
That's significant. So remember, Diata on retaining rights after divorce and Coleman on same-sex spouses.
Say cases, yes.
What about workers' children specifically, especially regarding education?
Absolutely key area. What was Article 12 of the old regulation, 1 Sins 1 268, now reflected in Directive 2004-38, guarantees that children residing with their worker parent in the host state have the same right to access education, including related grants and support, as national children.
The same rights?
Yes. The court interpreted this broadly right from the Casagrande case, which involved educational grants. And importantly, Achternack and Gall established that this right continues even if the parents leave the host state, as long as the child needs to stay to complete their education.
So the child's right is quite strong and independent in a way.
It is. And Article 10 of the directive now explicitly states that children in education and the parent who has actual custody of them retain the right to reside until the education is completed, even if the EU national parent leaves or dies.
So remember, Casagrande, Achternack, Gall, strong educational rights for children.
Definitely.
The Bombast case seems really relevant here too.
Bombast is crucial, yes. It dealt with a situation where the non-EU primary carer parent risked losing her right to reside, even though the children, who were EU citizens, had a right to continue their education.
What did the court say?
The court held the children's right to education meant they had a right to reside, and crucially, this meant their primary carer also had a right to reside with them to make the children's right effective. The court leaned heavily on respect for family life, Article 8 of the ECHR, in its reasoning.
So Bombast really underscores the link between the child's education right and the primary carer's right to stay.
Absolutely. It highlights the importance of making the child's rights practical.
Okay, so strong protections for workers and their families. What about people who become unemployed, or those initial job seekers we mentioned? What are their rights to equal treatment?
Well, historically, the Lebon case suggested job seekers had more limited rights compared to workers, mainly just equal access to finding employment.
But has that evolved?
Yes, significantly. The Collins case marked a major shift. The court extended the principle of equal treatment to cover certain financial benefits intended to help access the labor market, like job seekers' allowance, even for those looking for their first job.
So Collins expanded rights for job seekers.
It did. However, Directive 2004-38 in Article 24.2 seems a bit more restrictive.
How so?
It states that host member states aren't obliged to grant social assistance during the first 3 months of residence or during the extended job-seeking period, and it generally limits student grants or loans to workers, the self-employed, and their families until they gain permanent residence.
So there's a potential tension between the Collins case law and the directive here.
There is a nuance the court has tried to clarify. In Vatsouras, it said benefits specifically designed to facilitate access to the labor market aren't considered social assistance under that restrictive Article 24.2. They fall under the equal treatment principle of Article 45.2 TFEU.
Okay, so job-finding benefits are treated differently from general social assistance.
That seems to be the line. Also, the AV Latvijas Republikas, the Salības Ministrija case, established that even economically inactive but lawfully resident EU citizens have a right to access the public health insurance system, though subject to proportionality checks to avoid becoming an unreasonable burden.
So Vatsuras and Latvijas Republikas Veselības Ministrija show some specific rights remain, even for the unemployed or inactive.
Yes, but this leads us to think about whether there's been a generally more restrictive trend recently. Cases like Dono and Elimonovich often come up here.
Right. What did they establish?
Dono really emphasized that for economically inactive EU citizens to claim equal treatment for social benefits, their residents must comply with the conditions in the Citizenship Directive, crucially, having sufficient resources not to be a burden. The court essentially said member states can refuse social assistance to EU citizens who move without the means to support themselves.
And Alimonovich.
Alimonovich echoed this, particularly for job seekers whose right to reside is based only on seeking employment. It suggested they could be denied social assistance after the initial period allowed for job seeking runs out if they haven't found work and become a burden.
So the takeaway from Dano and Alimonovich is that accessing social assistance often hinges on meeting the directive's conditions for lawful residents, especially the sufficient resources requirement if you're not economically active.
That's a fair summary. It seems the court is trying to balance the fundamental right of free movement with member states' concerns about their social security systems, often termed benefits tourism, though that's a loaded term.
A difficult balance.
Yeah.
Okay, let's shift gears slightly. When can a member state actually restrict these free movement rights? We mentioned derogations earlier.
Yes, Article 45.3, TFEU lists the grounds: public policy, public security, and public health. Directive 2004-38, Chapter 6 provides more detail.
And these are subject to strict conditions.
Always. Proportionality is paramount. Any measure must be based solely on the individual's personal conduct, and member states have to consider various factors before expelling someone, especially long-term residents.
Okay, let's take public health first. What are the specific limits?
Article 29 of the directive is key. It refers to diseases with epidemic potential, as defined by the WHO, and other serious infectious or contagious diseases. But, crucially, restrictions can only be imposed if the host state applies similar measures to its own nationals.
And there's a time limit.
A very important one. A person cannot be expelled on public health grounds if the disease occurs more than 3 months after they arrive. And medical exams within those first 3 months are only allowed if there are serious indications, not as a routine check.
So after 3 months, public health is basically off the table as a reason for expulsion.
Largely, yes.
Yeah.
It's very limited.
The recent pandemic obviously tested these rules. What was the EU law perspective?
Well, the EU did implement measures like the digital COVID certificate. The Nordic Info case looked at national pandemic restrictions. The court confirmed states could restrict non-essential travel and require tests or quarantine during a severe health crisis.
With conditions.
Absolutely. The court stressed any such restrictions must be proportionate to the health objective, clearly justified, predictable, non-discriminatory, and allow for judicial review. So even in a crisis, fundamental rights and principles like proportionality still apply. Remember, Nordic Info.
So necessity and proportionality remain the watchwords, even in emergencies.
Exactly. Now, public policy and public security, these grounds can often be trickier.
The Van Dine case is often cited as an early example.
Yes. Van Dine involved a Dutch national denied entry to the UK to work for the Church of Scientology, which wasn't illegal but was considered socially harmful by the UK government. The court accepted that member states have some discretion in defining public policy. But it must be based exclusively on the personal conduct of the individual involved. That's now explicit in Article 27.2 of the Directive. In Van Dine, the court considered association with an organization could potentially count as personal conduct.
But wasn't that limited later?
Yes, the Adui and Cornwall cases clarified things. It involved expulsion orders against prostitutes. The court said a member state couldn't rely on public policy grounds to expel someone for conduct, which, if done by its own nationals, doesn't lead to similar repressive measures. You can't target non-nationals for behavior tolerated among nationals.
So it has to be about the individual's actions, and you can't use it to discriminate against activities that are legal or tolerated for your own citizens.
Precisely. And the threat level is important, too. The Bouchereau case is key here.
Bouchereau.
It established that relying on public policy requires more than just any breach of the law. There must be a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. Remember Bouchereau. Genuine, present, serious threat.
Not just any past conviction or minor offense.
No. And it can't be used simply for general prevention purposes, deterring others. It must relate to the individual.
What about people who've lived in a country for a very long time? Do they get extra protection?
Yes, definitely. Cases like Orphanopoulos and Oliveri emphasize that authorities must weigh the threat posed against factors like the duration of residence, age, health, family situation, and integration into the host country.
And the directive reflects this.
Yes, Article 28 provides enhanced protection. An EU citizen residing for 10 years can only be expelled on imperative grounds of public security, which is a very high threshold.
How is that assessed?
The Securitas case clarified things like the length and reasons for any absences from the host state are relevant when calculating that 10-year period and assessing the link to the country. For someone who spent most of their life there, the reasons for expulsion must be exceptionally serious.
So Orphanopoulos and Oliveri, Securitas long-term residence matters a lot.
A great deal.
And there's a case distinguishing expulsion from extradition, sending someone outside the EU.
Yes, the SM case. It clarified that while EU citizens don't have an absolute right against extradition to a non-EU country, any such extradition must respect their fundamental rights under the Charter, particularly Article 19, the prohibition against removal if there's a real risk of the death penalty, torture, or inhuman treatment.
So EU fundamental rights act as a shield, even against extradition?
To some extent, yes. And just to reiterate Article 27.2 of the Directive in Bouchereau, measures must target a genuine, present, serious threat based on personal conduct, not general prevention. The Ordre de Barreau case also confirmed enforcement measures are restrictions and need justification.
Okay. Lastly, on restrictions, that public service exception, Article 45.4 TFEU, where certain jobs can be reserved for nationals.
Yes, but again, the court interprets this very narrowly. It's about the nature of the post, not just who the employer is, as such you showed.
What kind of posts?
The court, in Commission v. Belgium, No. 2, defined it as posts involving direct or indirect participation in the exercise of powers conferred by public law and duties designed to safeguard the general interests of the state. It implies a special relationship of allegiance.
So real state power or safeguarding functions.
Exactly. Things like judges, senior civil servants, police, armed forces, but generally not roles like trainee teachers, Lori Blum, or nurses, Commission v. France. It's a very limited exception. Remember Commission v. Belgium, No. 2, for the definition.
A narrow exception for core state functions. Got it. Let's move now to EU citizenship itself. Article 20, TFEU, introduced by Maastricht.
A landmark development.
And the key principle is that EU citizenship is additional to national citizenship. It doesn't replace it. It depends on being a national of a member state.
That's fundamental. The Micheletti case confirmed it. Nationality is granted by member states. That's their competence.
But EU law still plays a role.
Yes. When member states exercise their competence over nationality granting or withdrawing it, they must respect EU law principles, especially proportionality. This came through strongly in the Rotman case.
What?
Involved loss of German nationality, which meant loss of EU citizenship. The court said the consequences of losing EU citizenship must be considered, and the decision must be proportionate. Later cases like Chebs, Wiener Landesregierung, and X reinforce this need to examine consequences and ensure proportionality in nationality decisions affecting EU citizenship.
So member states decide nationality, but within the bounds set by EU law regarding the consequences for EU citizenship rights.
Exactly. And the Petruhin case showed how EU law, specifically non-discrimination, impacts extradition requests between member states and non-EU countries when an EU citizen is involved, requiring cooperation mechanisms. So remember, Nicoletti and Rotman are key here.
EU citizenship also brings specific political rights.
Yes. Article 23 gives the right to diplomatic and consular protection from any member state's embassy in a third country under the same conditions as nationals. Article 24 covers petitioning the European Parliament, applying to the Ombudsman, writing to institutions.
But these rights are tied to holding member state nationality. What about Brexit?
The Préfet du Gers case confirmed this starkly. British citizens lost their EU citizenship and associated rights upon Brexit. The court upheld the withdrawal agreement, stating that losing EU citizenship is an automatic consequence of no longer being a national of a member state. Simply having exercised free movement rights before doesn't preserve it.
So Préfet du Gers is a clear reminder. No member state nationality, no EU citizenship.
Yeah, it's the legal reality.
Now, Directive 2004-38, We keep mentioning it.
Yeah.
It's central to understanding the practical rights of EU citizens and their families moving around, isn't it?
Absolutely central. It consolidated several older directives and aimed to simplify and strengthen the rights. Its preamble famously states, EU citizenship should be the fundamental status of nationals of the member states when they exercise free movement rights.
But it primarily applies when someone moves to another member state, not within their own country.
Generally, yes. The cross-border element is usually required. Cases like Morrison and Hanjan established it doesn't normally cover purely internal situations. So, remember, Morrison and Hanjan usually needs movement between member states.
We've covered the definition of family member under the directive.
Yep.
Any other points about how it treats family?
Well, it largely reflects the case law we discussed. Reed confirmed spouse meant married partners under older rules. The directive explicitly includes registered partners if the host state treats them like spouses. It also requires member states to facilitate entry and residence for durable partners and other dependent relatives, not in the core definition, meaning they have to seriously consider their cases.
And the surrender Singh principle.
Yes, that's important. Surinder Singh and Ackridge confirmed that family members can retain rights derived from EU law even when the EU citizen returns to their own home member state after having worked or resided in another member state. The prior exercise of free movement activates EU law rights upon return.
So Reed, Surinder Singh, Ackridge, important nuances for family rights.
Definitely.
What about administrative requirements? Residence permits.
As the court established in Royer, the right exists independently of the permit. The permit is evidence, not the source. The directive sets out the specific documents member states can require. Remember, Royer, the permit is proof, not the basis of the right.
And the directive also covers what happens if the EU citizen worker dies, leaves, or there's a divorce.
Yes, Articles 12 and 13 specifically provide conditions under which family members can retain their right of residence independently in those circumstances.
And perhaps the most significant right in the directive is permanent residence.
A very significant right. After 5 years of continuous lawful residence, EU citizens and their qualifying family members acquire the right of permanent residence under Article 16.
What does that mean in practice?
It means they no longer need to demonstrate they are a worker, self-employed, or have sufficient resources and sickness insurance. Their right to reside becomes unconditional, essentially.
Stronger security. Can it be lost?
Only through absence from the host country for more than 2 consecutive years. Articles 17 to 23 detail the acquisition rules. So 5 years lawful residence leads to permanent residence.
Let's broaden out again to EU citizenship, beyond just workers. Article 18, TFEU, the general prohibition of discrimination on grounds of nationality. How does that interact with citizenship?
It's been hugely important. The Martinez-Sala case was pivotal. It established that an EU citizen lawfully resident in another member state falls within the scope of the treaty, Article 18, regarding non-discrimination, even if they aren't economically active. They could rely on Article 18 to challenge discrimination in accessing benefits.
So Martinez-Sala extended equal treatment beyond just workers to all lawfully resident citizens.
In principle, yes. Though remember, Article 24 of the directive links equal treatment rights specifically to residing based on the directive, which brings back those conditions like sufficient resources for the inactive. So Martinez-Sala was key, but the directive adds layers.
The idea of primary carers also became prominent in citizenship cases, didn't it? Especially for the non-economically active. We mentioned bombast.
Absolutely. Bombast showed how the child's right to education could generate a residence right for the non-EU primary carer, relying on citizenship principles and family life. Then Zhu and Chen involved a Chinese mother moving to Ireland to give birth, obtaining Irish and thus EU citizenship for her child, which then gave the mother a derived right to reside in the UK with her child based on making the child's citizenship rights effective.
And Ruth Zambrano. That seemed to go even further.
Zambrano was significant. It involved non-EU parents of Belgian citizen children who had never left Belgium. The court said refusing the parents' residence and work permits would deprive the children of the genuine enjoyment of the substance of their EU citizenship rights, forcing them to leave the EU territory.
But that Zambrano ruling was narrowed down later.
Yes, significantly. McCarthy involved a dual UK-Irish national who hadn't exercised free movement rights. The court said Zambrano didn't apply. De Racy clarified that Zambrano only applies in exceptional situations where the EU citizen would effectively be compelled to leave the entire EU territory if their non-EU family member was refused residence.
So very high threshold now.
It seems so. Later cases like Ida, OSNL, and Budratari have further refined the conditions for residence for inactive citizens, especially minors, often focusing back on sufficient resources and not being a burden. So Bombast, Zhu, and Chen, Zambrano are key, but know the later restrictions too.
Finally, education rights and citizenship.
Yes, the court has definitely used citizenship principles to push for equal access. Grzelczyk involved a French student in Belgium, denied social assistance. The court said he was lawfully resident and couldn't be discriminated against based on Article 18 and 21 TFEU. D. Hoop concerned unemployment benefit for a Belgian national after studying elsewhere in the EU.
So lawful residence as a student citizen triggers non-discrimination.
Generally, yes, for benefits within the treaty scope. However, member states can require a genuine link or degree of integration for certain benefits, particularly student grants or loans, to prevent abuse. Biodar accepted a settled requirement could be disproportionate, but allowed requiring a genuine link. Förster upheld a 5-year residency requirement for maintenance grants as a legitimate way to demonstrate that link.
So Grzelczyk and D. Hoop show the principle, but Biodar and Förster show permissible conditions based on integration.
A good way to summarize it.
Wow, that's a comprehensive tour. Okay, for everyone listening, especially those gearing up for exams, let's try to boil this down. How should you focus your study on this huge topic?
Okay, first things first. Understand the basics. Free movement of persons is one of the EU's 4 fundamental freedoms, intrinsically linked to the internal market. Get that foundation.
Right.
Then, you absolutely have to categorize the individuals. Pay close attention. Are we talking about a worker, someone self-employed, a service provider recipient, a job seeker, or an EU citizen more generally, maybe invective? The rights and conditions are different for each.
Categorization is key. What else?
Know your core legal sources. Memorize the key treaty articles, Article 45 for workers, 49 for establishment, 56 for services, and definitely Articles 20 and 21 on citizenship. These are foundational.
Articles 45, 49, 56, 20, 21. Got it.
And Directive 2004-38-EC, you just have to know this directive inside out. Understand its scope, the definitions it provides, especially family member in Article 2, and the rights it lays out for residents, initial, longer-term, permanent, equal treatment, and the conditions attached.
So Directive 2004-38 is non-negotiable.
Absolutely non-negotiable. Then, case law. As you've heard, the Court of Justice has massively shaped this area. You need to know the landmark cases.
Like the ones we've discussed. Bozeman, Levin, Bombast, Zambrano, Dono.
Exactly those, and others like Martinez, Sala, Rotman, and Tonneson, Collins, Grzelczyk. For each key case, understand the basic facts, the legal question the court faced, what the court decided the holding, and crucially, the main points of its reasoning. Why did it reach that conclusion?
Facts, issue, holding, reasoning for key cases.
Yes. Also, be really clear on the difference between discrimination, direct or indirect based on nationality, and measures that hinder free movement, even if they seem neutral on their face, like in Bozeman.
Discrimination versus hindrance. Important distinction.
Very. And understand the derogations, public policy, public security, public health. Know the grounds, but always remember the principle of proportionality that governs their use, and the enhanced protections for long-term residents.
Derogations and proportionality, check.
Trace the evolution of EU citizenship. See how it started in Maastricht and how its importance has grown, especially in granting rights to people who aren't economically active. See how it interacts with, and sometimes goes beyond, the rights originally based on economic activity.
Connect the dots.
Exactly. See how the definition of worker impacts the right to reside and equal treatment. See how EU citizenship builds on or modifies those rights. How does Bombast relate to Zambrano? How does Dano limit Martinez Sala? Look for the connections and the tensions.
And practice?
Oh, definitely. Work through problem questions, hypothetical scenarios. Try to apply the relevant articles, directives, and case law. Think like you're advising someone in that situation. What are their rights? What conditions apply? What arguments could be made?
And finally,
use the learning outcomes provided in your module guide as a checklist. Can you confidently address each point? Use any quick quizzes or self-test questions available to check your basic knowledge and recall of key cases and rules.
that's fantastic. Really practical advice. So just to quickly summarize our discussion today, we've covered the fundamental principles of free movement for people in the EU and the concept of EU citizenship. We've seen it's a dynamic area, constantly shaped by both legislation, like the crucial Directive 2004-38, and the extensive case law from the Court of Justice.
And we've emphasized the need to understand the different categories: workers, job seekers, family members, citizens, and the specific rights and conditions attached to each, as well as the grounds for restricting those rights and the ever-present principle of proportionality.
Absolutely. And perhaps a final thought for you to consider as you continue your studies. How does this ongoing tension between individual free movement rights and the sovereign concerns of member states about their social systems, public order, maybe national identity, how might that balance continue to evolve, especially considering recent challenges like Brexit, pandemics, economic
What
pressures?
could be the next big test case or legislative change in this really fundamental area of EU law? Something to ponder.
Indeed. Well, thank you so much for joining us on this deep dive into EU free movement and citizenship law.
Our pleasure.
Remember, these materials are provided for educational purposes, courtesy of the University of London, and this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
We wish all of you listening the very best of luck with your upcoming exams. Study smart.
Good luck, everyone.